Hello there, this is Clifford from Clifford Odhiambo Advocates. We are located at Jumia Place along Lenana Road in Kilimani. There has been a steady increase in the number of litigation against insurance companies. Some of these cases have been as a result of insurance companies refusing to pick up the tab at the hospital long after the insured has been treated. This is despite such insured persons having valid and enforceable insurance policy covers. In other cases, the litigations have been as a result of insurance companies refusing to pay for goods and services offered but not paid for. Today we look at the recent ruling of the High Court in the case of Robson Harris Advocates LLP versus Invesco Assurance Company Limited. The ruling in this case was delivered by the Honorable Justice D.S. Majanja on the 25th of April 2022. This case may also be cited as Nairobi High Court Milimani Commercial Division Insolvency Notice number 54 of 2021. This case is particularly important as it offers us insight into insolvency proceedings against insurance companies. The present insolvency petition was filed by the petitioner after it alleged that the respondent had failed to settle its debt amounting to 41 million Kenya shillings odd. The insurance company in return responded to the claim by filing an application raising various points of law, key among them being that there was an ongoing insolvency petition and therefore the matter was sub judice. Sub judice in Latin means being subject under judgment or consideration before another court. The other issue that was raised by the insurance company was that the Commission of Insurance had not been included in the insolvency proceedings. Lastly, the insurance company claims that the petition is rigged with ill motive as the petitioner is using the insolvency proceedings to recover a disputed debt. We pick up this case from the court's analysis of the law, and from the case we learn that the learned judge was not persuaded by the arguments advanced by the insurance company that the matter ought to be dismissed because there was an ongoing insolvency petition. The court said for it to uphold such an argument, it needed to first appraise itself of all the facts of the case so as to determine whether the present case was sub judice. The court held that those facts had not been placed before it and therefore could not make the conclusion that the matter was sub judice. In responding to the arguments advanced by the insurance company that the suit ought to be dismissed because the Commission of Insurance was not included in the proceedings, the court analyzed the provisions of Section 121 and 122 of the Insurance Act. These two sections are very critical in that they answer the questions as to who, when, and how liquidation proceedings against insurance companies ought to be commenced. They also critically and fundamentally state that where an insolvency petition or application has been filed by a person other than the Commissioner of Insurance, the applicant ought to serve the Commissioner of Insurance. The Commissioner of Insurance, on the other hand, upon being served, becomes a party to the proceedings and is entitled to be heard on such application. Additionally, the court held that service upon the Commissioner of Insurance could be effected at any time before the hearing of the application, and therefore failure to serve upon the Commissioner was not in itself fatal to the proceedings. Insurers are in essence still companies, and therefore the provisions of the Insolvency Act apply to them. This observation was equally made by the learned judge, who observed that there was no provision in the Insurance Act that absolved insurance companies from the mandatory requirement under the Insolvency Act. Under Section 384 of the Insolvency Act, a company is deemed to be unable to pay its debts if, after 21 days of being served with a statutory demand, it still is unable to pay its creditor the sum of 100,000 Kenya shillings or more. A company is also deemed to be unable to pay its debts if a decree, judgment, or an order in favor of a creditor is returned to the court unsatisfied. Lastly, a company is deemed to be unable to pay its debts if it's unable to pay such debts as and when they arise. In the end, the court dismissed the insurance company's application, raising those various points of law, paving way for the hearing of the insolvency petition against it. Insurance policy holders who are affected by the placing of insurance companies under statutory management are often advised to seek recourse from the Policyholders Compensation Fund, PCF. This is a state corporation under the National Treasury. The fund was established to compensate policyholders who are affected by the placement of insurance companies under statutory management. The current maximum compensation is $250,000. The fund was also established to give confidence to the members of public in the insurance sector. In the beginning of this year, we represented our youngest client ever, aged below the age of 5, against her insurance company. In the case, we were able to successfully obtain orders compelling the insurance company to pay the sum of Kenya shillings 1,350,000 towards her emergency medical treatment. This case highlights that it's possible for a policyholder to successfully sue an insurance company and obtain compensation over and above that amount capped by the CPF, so long as that particular insurance company has not been put or placed under statutory management. Equally, from the earlier highlighted case, we learned that a creditor can successfully sue an insurance company so long as they're able to demonstrate that the company owes it a debt of Kenya shillings 100,000 or more, or that it has a judgment order or decree in its favor which judgment remains unsatisfied, or lastly, if they're able to demonstrate to the court that the insurance company is unable to meet its debts as and when it arises. Well, that's it for now. Hope to see you again next time.